So I get asked this a lot. So I figured I'd do a video on this specifically on trying to navigate moonlighting as a founder, as in building your startup while you're employed somewhere else. And many successful startups were born after hours, but that's missteps can still threaten your company before it even gets off the ground. The biggest risk, of course, is intellectual property. So under the vast majority of standard, proprietary information agreements and used with most IP-intensive companies, from startups to name brand public companies, but I think tech companies for the most part. Any intellectual property created that relates to the business of the primary employer or the reasonably anticipated business of the primary employer, even if created on your own time and without any of your employer's materials, is owned by the primary employer. And it doesn't just include code, it includes ideas, it includes business plans, know how, patents, customer lists. So even if you build something from scratch, your employer might still have a legal claim to it. But so, what do investors expect? Uh, put yourself in investors' shoes. No one wants to fund a company that might get tangled in a lawsuit over ownership. They want to see a clean break from the prior employer and confidence that your venture won't face IP disputes. Now, of course, this is assuming this is a pre-seed investor that does any due diligence, and I have seen pre-seed investors that clearly have done zero when I'm on a Series Seed round, the first price round, let's just say, or sometimes another converting securities round, safe or convertible debt note, but most of them are safes. But you shouldn't be basing it off of what kind of investor you think they are. You should be basing it off of assume you're going in with an investor that knows what they're doing, potentially even has legal counsel going through it. I mean, if they're dropping $500,000 in a round, I would hope that they did due diligence. This person clearly didn't in this case, but assume it's an investor that knows that is important and knows what they're doing. But so I mean, how do you protect yourself, and how do you protect, more importantly, the future startup? Well, obtain employer approval, get written approval um, in writing that states that they don't claim your side project. For most people, that's often not feasible or realistic. And as with many things, perhaps it's better not to ask for permission if you're not sure you'll get the answer you want. But two, leave early. The sooner you leave your day job, the lower the risk your employer can say the idea was theirs and not yours, or that they own it anyway. Review all the agreements you signed. Likely, this is all on during onboarding. You might have updated handbooks and company policy stuff, but um, most of this is probably going to be during the onboarding phase. So it makes common sense, but it's important to understand what you signed. The employment contract, offer letter, or employment agreement, the IP assignments, NDAs if you sign one, before making any moves to leave your job and do this because you're taking a big risk, potentially, especially if you're not exactly sure where you stand. But so let's assume you are going to leave. Stay professional, though. You shouldn't slack at your job while you're planning your exit. I've met a lot of entrepreneurs that actually were fixing a problem that their employer might be an interested customer at some point. So you don't want to leave on bad terms for that. I mean, they might be part of your network, but I wouldn't leave on bad terms anyway. You don't want to leave a bad taste in people's mouths, right? Especially future connections. 5, separate everything. No work emails, no work computers. Don't do it on work time. Just keep your startup 100% separate from your day job. 6 or 5 or 6, whatever. Document it all. Keep a personal log, kind of showing when and how you built your startup. It's a simple way to prove it's your own. It's frankly simpler now with all the new technology, note-taking apps, etc. Although I will say, read those terms of service just to. I mean, who knows? There shouldn't be anything special on, but I would still, if you're going to use some note-taking app, read the terms of service, just in case. But those are kind of the actionable steps you can take. That won't necessarily make you lawsuit proof, but they will reduce your risk and make your venture more fundable. Your startup deserves a strong foundation because you're putting your time and effort into it, and you need to make sure it's yours. So, I mean, that's a couple of tips that you can use, but that's all for now.